be recording this meeting, so I want you all to know that it's being recorded. I've had some concerns about people not recalling things. How many of you are executive directors of your school? Okay, there's only 5. 1, 2, 3, 4, 5. Okay. The reason I asked that question is this meeting is only for one topic only. SB 193, Senate Bill 193 passed. Early late in 2010, the board, after having 3 public meetings, the third public meeting, adopted and directed staff to proceed with a bill. We didn't know what it was going to be called at that time, to do 4 things. The first thing was to get authority, which was left out by accident in 2009, about threading establishments that the legislature surprised us with in the legislation being processed at that time, and withdrew threading from our chapter and then sort of haphazardly threw it back in. And then when they threw it back in, they didn't give us any authority to do regulations, sanitation or health infection regulations. And yet we were given the responsibility of doing surprise checks for that purpose. So we had to go back in and have that repaired. All that meant was they had to add a half of a sentence that said, and the authority to enforce. So basically giving us the authority by statute. That was the first issue. The second issue was that when we did in 2007 a reorganization of the licensing procedures, we went from everything all at one time at the end of June 30th, every other year. We got the individual licensing operation worked smooth as glass in the new design. It was just a long 3-year period to transfer everybody to the birthday-oriented DMV-style licensing. However, it did not work because the schools and the establishments are owned by partnerships, limited partnerships, and all kinds of financial configurations. So it didn't really work. So we had to go back and repair that item. That was item 2. The third item was that our legal people felt that there might be a worthy to do some clarification in the qualifications process of when people apply. It's inherent that you have to be a U.S. citizen or a legally resident and able to work in this country in order to get a benefit. And a benefit is welfare, medical service, licenses, and those kinds of things. So we put in a sentence in every one of our licenses that says you have to be a U.S. citizen or legally able to reside and work in the United States. That clears it up. It's very crystal clear. It's a copy of many other boards and commissions. Procedures has the same line. The last item was that the board had struggled for 3 years with the surety bond issue. It wasn't working. It's cosmetic in nature. It resists and restrains trade opening easy because new schools have to come up with such a phenomenal amount of surety bond in order to even get licensed. We asked, the board had beat that around for a number of periods. And speaking of the board, we have a guest from the board, the president of the board, our board chair, Kathy Ditzler. Do you want to make any comments or say hello or go to hell or whatever it is that you do? Like you tell me every morning?
I'm very happy that there's so many people that have taken a concern in this and want to look at this and discuss it. Because it's very, we've looked at this pretty darn hard.
So what occurred was in the final stages of 2010, since we had missed what they call the governor's window for agencies like ours, normally what we do is we propose NRS changes. It goes to the governor's office, and it competes with 500 or 600 other bills to get published by the governor and moved on. The governor only can submit 100 bills a year each session from his office or her office. So we missed the window on that. So we had to go get a private legislator, individual legislator, either senator or assemblyman or assemblywoman, to sponsor the bill. That was done. Senator Hardy, Dr. Joseph Hardy, had been part of another bill in 2009, was quite familiar how we operate and what the procedures we go through, was willing to carry our bill. So the fourth item was to repeal the surety bond outright. We had looked at reduced amounts. We looked at different configurations of a surety bond, and all we found was, first, the surety bond companies or insurance companies, there's a number of different companies that handle them, don't like doing them. They don't want the business. Too many of them were failing nationwide. Secondly, quite often they end up, a surety bond is not an insurance policy. Most people think it is. It is not. A surety bond is an insurance company or bonding agency who says, we think you're solid financially, and therefore we're willing to put our name and money behind your reputation. And so if you fail, we'll pay off the debtor, the people who you owe money to. And then we'll come back for you, and we'll get it out of your hide. They don't lose that. It's not like I was involved for many years with what they call joint umbrella policies by a number of cities coming together as a group, buying large covered umbrella policies, and each agency paying their fair share to the pool to pay for the minor expenses as we go along. Those are called pool type insurance. Surety bond's not like that. So if you have a house and you have a car and you have whatever, when they pay it off, they're going to file a lien against everything you own to get their money back. So it's not like a pooled system. So when we asked them outright, they told us that we don't really want the business, but the law prohibits us from not issuing them, so we make the price real high. And the price has been going up pretty high. And they range from anyway from $3,000 or $4,000 because you got a great reputation, you got a deep pocket, you own 14 schools, that kind of thing, all the way to $12,000 and $14,000 per year. Plus, we were told newer schools that do not have a strong equity base will have to put up quite a bit of equity to cover the amount. What they were talking about was 50 to 100% of the number that's on the table. So if it's a $400,000 bond, they could say, it'll cost you $10,000, plus we want you to put up 50% of all your equitable and negotiable instruments, i.e. cash in the bank, a house free and clear with title, and those kinds of things. So they can grab it immediately. So, and what we were finding in the history, at least since I've been here since 2006, we've had 3 schools fail. They had never had a school fail prior to that, but in the recession we had 3. 2 are on not good ground. 1 is in very serious condition. And of the 3 that failed, only 1 had a surety bond with $10,000 that didn't cover anything. The students walked away never getting their money back. They all went to court. They all won. The number of youngsters went to court, got a judicial district award by the court saying, you're right, the contract says they owe you the money, we award you the money. Then they don't get their money because there's no money. They get in the back of the line to the bankruptcy court if it's bankruptcy, or if it's closed, you got to find the guy, you got to serve the papers, you have to collect the money, you have to find their account where the money is stored if there's any. So in reality, after consultation with the insurance commissioner, we found that the surety bond was cosmetic. Great expectation that government lays out for everyone and doesn't produce what is promised. So that's the reality of it. That's what I testified to the legislature. So we went to the legislature with the intent to repeal it outright and force us to do better work on a daily basis, inspecting the schools, looking at their financials if we have the legal ability to do that, and that sort of thing. The legislature passed S-193 through the Senate that quick. They actually asked the insurance commissioner to come and testify. He came personally. We met with their staff prior to that meeting, in which 3 of their top guns sat around the table while I was on the phone, and we talked about options, what's available, other alternatives, what do they recommend, that sort of thing. They had none for me. The bill actually got into the assembly, and was 2 amendments were added to it, so you're aware of it. The First Amendment that was added without being warned is a hair braiding license being created by a third party who had contacted our bill sponsor, and the bill sponsor had agreed before they contacted us. So what you see in the final law is what they think is the appropriate way to go, not whether we think it's good or bad. We were already working on a hair braiding license creation because we had been approached by a number of other parties. We've been seeing the message across the United States that this is a coming entity, this is what's happening throughout the United States, and about 12 or 13 states already have it. And they vary from 100 hours of training to 600 hours of training for a hair braider. I was offered the first pass when they told us that the amendment was being added, was that we'd have to accept 8 hours of training and then licensure. And that was not acceptable to the board, so we rejected it. And then they started playing with the numbers, and this is what we ended up with. The second issue was an amendment was added by Maggie Carlton, the senator, used to be a senator last session, is now an assemblywoman. She turned out as a senator and went back and ran as assembly. And she demanded that, although she understood the issue with the surety bond problem, she said she would rather have some kind of invoicing and collection payment process as an alternative. She crafted some wording that was plugged into the bill. A number of schools in the state, there was 5 that I'm aware of, objected to it. Now let me tell you, 2 of the schools testified in behalf of elimination of the bond in front of the legislature. The bottom line is when when the 2 sides, Senate, Assembly, could not agree on these 2 amendments and the parameters of them, they then are forced into one of two ways. The bill dies automatically, everything stays as it is, or it goes to conference committee. Conference committee gets 3 members from this House, 3 members from the Senate. They sit down and they iron out their differences, and they dictate what the law will be. We were invited to sit in but not talk. We weren't allowed to say anything. We only could respond if they asked us a question. They didn't ask any questions. So what you see is the final version, and this one with the green thing, is the final version that the governor signed. That's law. I have no choice except to execute it. What I've tried to do, I went through this with a fine-tooth comb. I had staff look through it and see if I was making a mistake in my interpretation or reading. And what I did is I drafted 2 documents. The 2 documents are to help explain what is law and what is negotiable still. Okay? The surety bond, obviously, is well explained on page 1 of the first document. And it says, items be resolved by the Board of Cosmetology. What that means is those are ones by law that have been designated by the legislature that we have to, they're already decided for us, we have to implement. That we don't have a choice there. And that's what that explains. And that includes, I did it in 2 versions. One is the first page deals with the surety bond issue, second page deals with the hair braiding issue. The second document is a 2-page document. It talks about, I try to separate it a different way to make it even easier to read. And the first part is those issues that are dictated to us, those issues that are still open to discussion. And the way we'll deal with those areas that are still negotiable is the board has been designated or given the responsibility and the authority to develop regulations through the rulemaking process. And I'll talk about that in a moment. The rulemaking, the authority and to develop regulation means the board must develop regulations, and they must use the following process, and they will decide these issues. And these are the issues that they suggest, the process, how it works. This meeting is a non-formal, non-required meeting as part of the rulemaking process. It's an extra meeting that I added on as a courtesy to make sure you fully understand all the issues and what authority you have and what authority you don't have. That's a courtesy from the staff's position that if everybody has all the information as it is, then we will all get to better decisions without a lot of discomfort. The next meeting will be scheduled as soon as we have, we can free up the board members so we know when they can all get together and we can schedule a public workshop. A public workshop is a recorded, noticed meeting. A notice means that we post that on all the usual places. Now, we normally, every board meeting, approximately 2 weeks in advance of the meeting, we mail the board packages. When we mail the board packages, we also notice every school via fax. So if your fax number is not getting the notices, you need to tell us what fax number we should be sending it to, because on every agenda you will see on the back side of it the noticing list of all the schools in the state, as well as every single library in the state, plus we post it on the website. So that means that you've had legal notice. Whether you read it or not is your problem. Whether you follow it or not is your problem. Whether you come or not is your problem. But that's what the law requires me to do, and that's what we do. The second, and the workshop is going to be take input by the board. There's a chance to all your proposals, and we will, anything we get today in writing, we will include in the workshop as being brought forth by somebody in the school family. The second meeting that will occur about a month later, and there is some legal requirements in the rulemaking process that says you have to separate certain meetings by 30 days. It's done to delay the process, slow it down, and make sure everybody has an opportunity to put their 2 cents worth in. That'll be called a public hearing. Now, the public hearing has a little more depth because from the workshop, staff is directed to try to put it together into proposed regulations. That's when you argue, well, I like this one, I don't like that one. Some of you have been through that before over the years and understand what that means. But that's where the 2 major inputs are done, in the workshop and the public hearing. Then the third meeting that's required by law, don't quote me on it, I believe that meeting can follow the public hearing immediately thereafter, or can be scheduled anytime thereafter. And what that does is the board actually says, this is what we've decided, staff, this is the ones we'll adopt as the board's official position. That is then taken before the Legislative Commission in Carson City, and 6 members of each house sit on that commission, and they're the final authority. And what they decide becomes law. A regulation is law from a different format. In the meantime, when we're going through this 3-meeting process, anything that deals with sanitation or infection control, health concerns, must be approved in advance by the health division of the Health and Human Services Agency of the state. Every commission has that same kind of regulation. So we will take those things that we deem infection control or sanitation issues, we will go before the health division, and they must bless it before we can bring it back and take it to the Legislative Commission. So that's how the process works. The regulations, in fact, are what they really mean is the NRS is the authority and the direction of the state. The regulations are the implementation of that directive. So they put the authority. You have the right, Vince, you have the right, the board, you have the right to do A, B, or C. And the regulation is how you actually do it, the how-tos. Annie, did I get that right?
Yes.
Because we talk about this all the time in this town. All right, so today's meeting is making sure you understand what's negotiable, what isn't. I didn't have any right to negotiate the stuff that got put in the law. I was told what we were to accept. Now, it's real interesting dialogue when you get through that. The typical committee will say, well, what do you think about this? And you say, no, we don't think that works or not works or will work. And they'll say, thank you. And then the next day you find out what they thought about it. And it's usually in writing by some legal beagle in the LCB staff, LCB has a whole cadre of attorneys that do nothing but write things. And then we see what we've got on our hands at that time. When we went to the conference committee, I didn't see anything until the day of the conference committee, 5 minutes before it got discussed. So that's where we stand. So I wanted to make it easy for you to understand how it's working. Now, I wanted you to be aware that a number of schools, and this is something you need to worry about, is documents that don't get sent in that you're supposed to send in. Most of the schools when I came here did not have records of any type of the bonds that they were supposed to have on file, in our files. They hadn't sent them to us, they hadn't delivered them to us, and we went out and we contacted every single school and we brought the file up to date. And you remember that? I think Amy Tanner was responsible for that one. Within 6 months, there's always somebody who got a new bond, forgot to send the copy of the notice in to us. Good morning, Michael. And so that file is pretty complete. Because we were going through renewal now, we have all the documents we're supposed to have. So let me tell you about the bonds, so then we can talk about what you want to input to the dialogue. From July 1st, no bond is required, period. Whether it's 10 or 400,000. They repealed 644.383. What that means is there's going to be a grace period of a few months. Because what they said is, we're repealing the way it is, we don't like it. But we're going to do something else to replace it. They're going to replace it with 2 separate approaches. And the schools will have a choice of either one. One is the board will be required to hold through the rulemaking process, establish regulation that will dictate the new surety bond level. That's what this meeting's got to do with, is what is that level? How should we deal with it? There's all kinds of questions that could be influenced. But the board will make a decision later on in the year and adopt a regulation they believe is appropriate, and then they'll start pushing it through the legislative commission. That's who will make the final call politically, because it can't become law until they approve it. So that's the first issue you want to think through, is what is the proper amount for a surety bond? Even though I truly don't believe they work, that's what the legislature wants, that's what they're going to get. We follow the rules. The second part of it is, in the old one, they had all kinds of, they had a formula that didn't work. Formula, when you ran the formula, and Miss Curtis will remember this, I asked her to run the formula for 25 students, brand new school, and what would the bond issue number be? And when she came back, and I forget what the exact number was, but it was something like $420,000. But the law says you can't have any more than $400,000. So guess what that meant to me? The formula was a sham. It was $400,000 no matter which way you look at it. And I don't care how many mathematical calculations you do. I was an engineer. I know math. It doesn't work. And so that was an issue that the legislature talked about in the hearings. They also talked about, the equity of one group getting smaller amount, one group getting bigger amount, and those issues. And the board has discussed that ad infinitum. So that's been dialogued a lot. The issue is, where do you guys stand on that? What do you think is fair and equitable? What do you think is the way to proceed with that? Because that will be taken in as input into the dialogue in which the board will have to make a final decision that they'll have to defend publicly in a political arena. That's the first issue. The second issue is Miss Carlton said, I want the focus of this bill is to protect the students, period. Not the schools, not the board, but the students. In that, I would like to minimize their exposure to financial loss should a school collapse due to financial problems, bankruptcy, I retire, I'm just closing the doors, I don't care anymore, or whatever reason. And the history has been over the last several years is the students are left holding the bag with no money. They paid it up, but they get nothing back. Some are only 50 hours behind because they pay on time. Others have paid, grandma paid it all, and they got nothing back. And others are on payment plans of some sort. The federally funded schools that were approved and funded, and if that's the type of school that failed, is really a non-problem, because under the federal regulations, and I deal with the feds all the time on these issues, is that they have the power to shut the funding off to a school that's not functioning the way they like it. They can force you to put letters of credit on the table, which is not a good thing. So if you're bragging about it, don't be bragging about it. That's like you got bad credit, and we're going to make the bank put money on the table for us to grab whenever we want, not when you want. Understand what that means. And the other thing they can do is they just don't give you money for their students anymore, period. So they have power. So in the collection process they use under Title 34 CRF, and the law, its specific law is 668.4, and the subsets of that. That's the funding law that provides for the payment of money to the schools, and when it's paid, and how much the schools have to guarantee this education's been delivered. So that's the process that the legislature liked. So that what they did to it, so you understand what they said, it says shall be the alternative plan for a school, instead of a bond, and use this alternative way of collecting money and imposing the debt to the student that is acceptable to the state.
And they just changed it.
And that's why. But it only said modeled after. It did not say adopt. And here's the law that most people don't quite understand when they read stuff, is when you say adopt the provisions of federal laws blankety blank, that means you copy exactly. When you say modeled after, means something that's acceptable to the state that is in a configuration like the feds, but not identical. So there's some flexibility for the state to work. And the example is the equity position of the players. First thing I looked at was the equity position of the schools, equity position of the federal taxpayers' money, the deep pocket, and the equity position of the student. The student has no equity position, no power, no way to protect themselves. They're really at the vulnerability of what the schools and the feds decide. If they're a funded school, they have all these provisions that were approved through regulation by the federal government, which is the same process we have. It's a very similar process. Take input, have public hearings, workshops, blankety, blankety, blank. The problem with it is that if you go by the federal government, who owns all the power, because we give you the money for the student, and you copy that identical, the student is left with no power whatsoever. Schools get to call the shots. And that's not going to happen, to be honest with you. That the board has got very strong concerns about the students' position in this, and they're going to say the legislator ordered us to minimize the vulnerability of the students. We don't care about the school's position on this. They're worried about the students. My position is, why are we in the surety bond at all? Why it's a protection, it's a promise that we can't meet. Why do we have that? But they did a sort of cut the baby in half, give them half, take back half. So for what you guys have to think through is what kind of alternative plan that would be acceptable, considering, I don't know, the feds change their rules periodically. The difference is I know what the rules of the feds will be because I'm meeting with them later this month in San Francisco to their division, their regional headquarters, and I'm going to talk to the people who actually enforce the law. Because that's people.
There's been major changes.
They've not published them yet.
Yes, they are. They went into effect July 4th.
Oh, that's all gainful employment stuff, probably. No.
It's more than that. It's now they pay at the end of the payment period the satisfactory progress that develops. And
yeah, I saw some of that in the news.
That's all been changed now.
So the issue is what we think is acceptable for our state. So I'm going to be I already have the laws on my desk. I've reviewed them a couple times. I've talked to two of the representatives who actually do the inspections and enforcement and write the final reports on the schools nationwide and Western United States wide. And not just for cosmetology schools, but for technical schools, aviation schools, you name it. They're willing to sit down with me and tell me exactly how it works. When they pay, when they don't pay, how they pay, what happens if. So I'll be working with them to get...
You come in my office, I'll teach you. I've been doing it 30 years.
Well, I hate to tell you this, bust your bubble, but the last several schools who were audited that were found to be in violation had seasoned vets who were doing it. So the trouble is, because they are complex rules.
No, it's
very complex rules.
Have you looked into what California's been doing for years? And of course, it's subsided for a couple of years when the bureau closed with the Student Tuition Recovery Fund.
Yeah, I've seen that. That was sort of thrown out in early discussions, but when they saw what the numbers might look like on a regular basis, they didn't want to.
Well, but you say you want to protect the students, and it's an insurance fund that the student actually pays when they start school. And therefore, if the school closes, they can apply to that fund and obtain the monies to continue their education.
My understanding was the school paid it out of their proceeds.
No, the student pays it.
We're from California, from Marinello. The student does pay it. It's about $2.50 per $1,000 in tuition. And it goes into a fund which is available if the school closes, bankruptcy, whatever the issues, and it's available to the students.
Yeah, I'm not sure Nevada will accept that. I'll tell you what. No, the legislature won't accept it because they see it as another tax.
California has 90, far more schools than Nevada does. Cosmetology, they have over 200. Okay, there's been very few cosmetology schools in the last 10 years really close. At one point when the legislation and the Bureau went in, there was about maybe 75 to 80 cosmetology schools.
The problem with the California system, they don't do inspections. They can't answer any questions from the government side. They don't know what's going on in the schools. They're left alone. California. They admit that to us directly.
Well, they don't have the staffing, but they're getting a lot harder. They're making a lot more.
I understand that, but we have inquiries about selling of hours. Schools that are supposedly legitimate, and they can't answer anything.
That is the state board's fault because like I said, I've been in this business for over 30 years. And basically years ago, and some of you veterans will remember that have Marinello schools and that years ago we used to have to file a 4-ply form when a student enrolled, and it went to the board. They stamped it, sent it back. They had a record then. Okay, once they did away with the 4-ply form, that's when the selling of license, proof of training went rampant. It was mainly predominantly.
I understand. I come from California.
Yeah.
And I also know what occurred in Proposition 13 and how they decimated the staff and what's occurred when Governor Schwarzenegger got in a beef over the cosmetology and the boards in that area, and he fired everybody and closed it down.
Well,
so I know all about all that because I talked to the people who run it.
Private post-secondary.
But no, the cosmetology board they dismantled. It was not operation for a while.
A couple of years because it sunsetted.
Well, they automatically took it away. They sunsetted just like you can do here.
Well,
but the problem is,
by natural legislation, and then it wasn't.
What I'm getting at is copying a model that's failed miserably is not the way to go unless the model itself is okay, but the management of the model is where the problem was.
Right.
So the issue is, I don't think Nevada legislature is going to stand for something that they look at and say, well, that didn't work. Why the hell you give it to us?
So, Vince,
So that's one of the problems we got.
So skip over California because obviously that didn't work. So is there another state that you would consider modeling a program that's had success?
I don't have any particular one in mind or anything, and I'm open to what we can cobble together here because I think we're a small state. We should be a model state because we're only 2.7 million people. We're not 36 million people in a chaos of governmental red tape. So the issue is this legislature has made it very clear to me what they want. What they want is a two-prong effect, a decision on a surety bond, and that means that you have an option. If you don't like that number, you don't like the way it's configured, you can take a secondary view, and that's where the negotiation needs to be also clarified. Is I don't have a problem with the surety insurance fund, but I don't think that's the student's responsibility, to be perfectly frank with you. That's the school's responsibility.
But could the school purchase that on behalf of each student?
Well, that's something that we'd have to see if, first of all, the legal bills, the LCB attorneys say that would be an acceptable option under the regulations that the authority we gave you. If they say yes, then that's an option that we could all talk about. But that'll have to be asked.
So there's no other state dealing with this issue right now that's put together a program? I mean, I can't imagine reinventing the wheel here.
Let me ask Kathy to respond, because when she was off at different responsibilities as board chair, she actually did a survey of schools. Kathy, do you have what are other schools doing right now? I mean, what are the states doing?
The other states are, the majority of the states that I interviewed did not have surety bonds, for the simple fact is they don't work. Because it's an expense that is basically that you are putting out. I don't know, you may transfer that onto your students. But as far as if any of them do, they're anywhere from $5,000 to, I'm going to say the max was probably 15. Now, when you put that on paper and you look, that doesn't even cover one student. So, I mean, and we all agreed when we were talking about it that it's just something that they put in place and they've got it in the back somewhere. It's not, right, this was a major thing here. When our the schools were telling us that $400,000 bond is impossible to get, and it's inhibiting their ability to open a business and to do exactly what each one of you are doing. And that was one of the things that the board had looked at, is what purpose did this serve? And we are here to protect the student. We're here to protect the public. We're here to protect all of you, but we're not the insurance company. So,
what did the insurance commissioner have? What kind of programs that he said were available, such as what we're talking about?
None. He testified before both committees.
That there's no.
He says contractors boards have similar
policy.
problems, and he said we can't offer you any solution to it. Alternatives. We asked them to submit to this committee if they would submit their position from the insurance commissioner's office, what authority the state would have to do that, to mandate it. He says we don't have any programs for you that are working at the moment. So and that's what he testified on the record.
Let me throw something out here at you. Title I of the schools, I believe, in the state are Title IV funded.
No. But not all of them are. Any of the new ones can't be part of it for 2 years minimum.
Right.
So they're all trying to get it on board. But I would say 75% of them are.
What if they were, the department that requires a yearly audit?
That's not enough.
You can see that the schools are starting to run.
By the way, that was asked the legislature.
Okay.
Whose authority is the most powerful in this process? Bottom line is the state of Nevada. Without our license, you don't function. Period.
Right.
So the bottom line is everybody want to use the federal government as a backup in their inspection. We have no control over any of that. So the issue is they're not willing to accept that as a solution. Because I offered that. I said the protection that we have by just eliminating the surety bond, period, is we have the right to inspect a school at any given time, and if we get any reason to believe that they're financially unsound and can't meet the minimum obligations, we can then haul them before the board, and then we can talk about what we can do to solve that. The second thing is if you don't want to be a federally funded school, you don't have to be. There's no requirement. That's a business decision. And the federal monies are monies that are provided through the taxpayer's pocketbook to fund student education with the hopes of getting it back someday. Now they're talking about forgiveness. The current administration has talked about, well, we won't ever have to get it back if they spend 10 years in the business. That may never fly, but that's what's been offered to Congress. Yes?
Well, I basically, my voice this morning, excuse me, but I think that it's not the state board's, I don't want to say job, but place to monitor the school's financial situation, because at one point when you open a school, you could have proper financials. 6 months later, anything could happen. You might not have them. So I do agree that we need to have something in place, but to have schools to open undercapitalized, I mean, that's what we'll get, Vince. The bottom line is we all know this. You know, we all know the dream is to open a school. We open the school, and 6 months down the line, what happens? Okay, so it's the school that closes, the student that loses. But the bond issue, I have a $400,000 bond too at one of my campuses. So I do believe that $400,000 is not the number, but there should be something in place without a bond. I mean, I just disagree.
You know, the letter of credit is not the kiss of death from what I gathered on what you were saying, because a lot of new schools, like going into the federal programs that don't meet the financials, have the option of posting the letter of credit for a year or whatever. So maybe that if a school, if you could see by the financials that they're starting to fail, maybe then you could require a letter of credit, okay, that would cover if the school closure to reimburse the students. But again, I can't believe that the student tuition recovery that we have in California, we have 5 campuses there and 1 out here, that there isn't something available to Nevada through the same indemnification company that would help, because we're not having the school closures that we had. We have more institutions in the state of California that are non-Title IV operating. Okay, and the fund is being paid and paid. The only reason it failed before, when the Bureau, before they went out, was sunsetted, was because there was a lot of theft and overcharging and all kinds of craziness in the bookkeeping that went on. Okay, so the Bureau's mismanagement of the fund. Now that it's back, it's recomputed, seems that it's working. It's working.
Go ahead, Ken.
I do have to say that I do not think it is the board's responsibility to check the financials, because that's an infringement, I feel, into your business. I mean, that would be like in any entity that we have any business, someone coming in once a year and checking whether I'm doing my business properly. But what I would like to ask is, if there's an objection to maybe working on what Assemblywoman Carlton had suggested, as far as a student paying so many hours up front, and when those hours are achieved, pay that again until their education is taken care of, rather than doing the bond or any type of bond, because I don't feel like that's something that...
The model she's talking about is actually the way the state universities operate. You pay by semester. And then each semester you get credit for those that you complete. And then the next semester you have to pay another fee or you don't go.
I just like the option of having a choice. So, I mean, I'm going to be just kind of working with the state board on making the decision. I want a choice.
A choice of...
If I want a bond, the bond amount, we need to have one I feel in place. If the school wants to acquire a bond, that's the school's business. I mean, it's an option. We have
It's a
two
business-
options, and I think we should
business
be...
decision.
And I have to say that when I started this, doing the research on this, that I said it's not our place to tell a school that they have to have a bond.
Right.
It's up to the student themselves to make sure that that school is financially stable and can handle what they're doing. But now the legislator, on the other hand, has said we've got to come up with something to protect.
Yeah, we don't have really a choice. We have to come up with something. Dr. Elias, when he explained it, the California system to me, it was the schools were paying the fee. Now it's changed to the student paying the fee. I know.
It went back and forth.
I will tell you this legislature will not accept anything in which there's more taxing of the individual to get there. Ain't going to happen. They were very clear to me about where their priorities are. We don't want to close businesses down unless they absolutely have to be, and we shouldn't be the hurdle that's causing it. Secondly, no more taxes, no more additional fees, no more additional burden. So they were very clear on it. But that's today's marketplace.
But the school could still pay. I mean, if we had an option of $400,000,
Well, that's an option you can offer up.
You know, what I'm saying is, if we had an option between a $400,000 surety bond, which is what we're carrying now, and paid $2.50 per thousand on the student, you know, our average strep at our school is on a quarterly basis it's paid, and we probably pay about $2,700 total for all of our campuses, for 5 campuses.
And you think that'll generate enough money over the next 5
Well,
years
it's every
to cover
school in the
anything?
state of California that
We only have 19 total. One of us is exempt
excuse me, we have over 7,000 schools in the state
in
of
California,
In California.
but not in Nevada.
Right. Yeah, but see, so it's not going to be in your vocational schools here aren't being forced. Well, then why are we being forced? Why are we?
Because we opened the chapter by trying to get minor corrections, and the legislature takes opportunity because somebody walks in the door in one of their offices and says, "We want to do this," and we have no choice but to deal with that at the legislature. And the legislature is dictating to us what we'll do, not what we told them to do.
But don't they have to make it for other schools as well?
No, there's no liability
Really?
whatsoever for that. Unless they want to pass an omnibus act that covers all schools, and they don't want to do that. They don't want to talk about that at all.
Why
They
are
only want to
making
talk
it
about chapter
cosmetology?
because we opened the door about correction of other things.
Oh.
This is politics, guys, hard politics, and there was a lot of politics played, some of it not very nice in the process, but that's what happened. But we put that aside and we get back to what the directions are. You have a question?
Are we set with the $400,000?
No.
Or could it be a
It's zero at the moment.
Right.
So what? And those the legislature said there was objection to getting rid of it completely. So the legislature did not make the call on the number. They said, "Board, you get stuck with that task." So they laid it at our doorstep to make that call. That's what we're talking about. What do you guys think should be for everyone? Should it be structured? Should it be layered? Should it be all for everybody has to abide by the same law, the same rule? That's yet to be decided.
I just feel that we should have a choice, whatever it is.
Yeah, and the second alternative is the alternative plan for schools
What
that
kind of
don't.
choices can you offer us?
Well, they offered 2. Either take a bond that you guys will now make a new decision on it, or a collection and payment requirement fashioned after the federal fund approach to it with the flexibility, because they made it very clear to me that modeled meant flexibility there. That is not, we didn't adopt because I talked to the lawyer that drafted the number. I said, "Does this mean we have to copy exactly?" He said, "No, you don't. It means it just got to be structured like." So we can talk about that. So the issue, those are the 2 options the law gave us. They didn't give us any other options. So what we're doing is asking for input. The issue is we can make the call, but the rulemaking process in crafting regulations means that everybody puts their 2 cents worth in, and then the 7 members of the board make the call, and then they take it to the legislature. Now the legislature can easily, the commission can say, "We don't like what you brought forward, do it again." And they can do that as often as they want. But we can't get it.
Plan option.
Beg your
We're
pardon?
talking about. What are we looking about monetarily to the schools?
I don't have any idea yet. We haven't made any real discussions. A bond issue right now can range for a $400,000 bond, anywhere from $4,000 or $5,000 for the companies that are sound, to $12,000 to $14,000 for a single mom and pop operation
Right.
that doesn't have doesn't have a long history with them. Now, if you're with an example that one of the northern Nevada schools has 13 or 14 schools in several states, they don't have a problem getting a bond because they have a long history with the bonding agency. They got a lot of equity in their system, so they have no problem. They don't have to put up somebody's house. Other single mom and pop operations have to put their, the land that they own across the road for vacation property, their house, their car, whatever else, and if it's not enough, they don't get a bond because we don't know you. So that's the problem, and it's been a problem, and that's what they explained to me and talked to the insurance people about how they go about doing analysis. The first thing they ask was, "How much are you worth?" That's the first question. Well, I don't know. I'm worth maybe $1.5 million. And you want me to guarantee $3 million bond or $400,000 bond? How are you going to pay it back? That's the problem for them. And they don't get it back. So they have to go chase them down and all that stuff. So the issue for us, I explained it very clearly in the material. we have, on the surety bond, we have really two issues. What's the size of the surety bond? And how is it administered? Is it 200,000? Everybody pays the same? Is it 100, 200,000, and then in 5 years, if you've had no problem, no nothing, and you can show financial stability, however that's done, we drop it to 100,000, see what I mean? Then all that's open to dialogue. I think Gwen said it very clearly. She wants two options. You either want a bond, whatever the number is, or you don't want the bond, you'll take the other one.
And then I like when you open for 5 years and then.
Those are all things you guys should present as options. Then the board can argue it all out. But those are the things you guys you have to do your homework.
So you're saying that both those options are good, you just want to be able to make your, each
I just want to be able to
Okay.
make choice.
The bond's getting harder and harder to obtain because every year when you go to renew, you get subjected to more credit checks
So
and
if you choose not to take the bond,
Right.
then you'll have to take the other option, which is payment.
A payment period of some type that we
which
we
we're
negotiate
doing
out.
with the federal government with their changes, their payment.
No, we don't adopt their regular
No, but I'm saying
fashion.
we're used to that.
Yeah.
That's how we're paid anyway. So
Well, I know I participated in the gainful employment dialogue and been around to that. I've got the final report. And I understand how the feds work. I've also been involved in the oil industry many years ago when they were doing oil industry regulations.
Well, I do like kind of the California has we come up with our own system. Because if a school does not have any type of security, I just feel, because I'm working with a school right now, and I shared this with you, Vince, in Columbus. This lady was financially sound when she opened her doors a year ago. I said, within just a letter of credit, she had a $35,000 letter of credit, all her state board required. And now she's on the verge of needing to bail out or closing her doors. What happens to the students?
That's what happens every time.
Right, so we need to come up with, I think, an alternative method of schools making maybe some type of payment into the fund and not having the students to pay it.
Right.
Maybe the school is responsible for paying X amount of dollars. I don't know, but we need something.
Well, that's what I say is once somebody has an alternative that they're offering up, then we can make inquiry to LCB to see if their
And we
attorneys
can do
say.
some research, Gary.
But the bottom line is now this is your early warning that this is how it's going to be done. And if you don't participate or you don't have any ideas, that's one thing. But if you have ideas and you don't say them, it's your own fault.
What's the time element involved? Like, could you get a little small committee where we could meet with you and bring different things to the table? Maybe.
I'm not the negotiator for the board. What I would be willing to do is to, if you want to have meetings where you say, we have one of the proposals we'd like to present for you, that's fine, we can set up a meeting to do that. But that's intended, what this meeting was intended to start for you, is that when they're supposed to really be brought forward now, will be in the public workshop. But if in advance of the public workshop, you can say, do you think this will fly or not fly? I'll give you my 2 cents worth. And if I say, I don't think it'll fly, then if you want to bring it forward anyway, that's your right. I'll sit quietly while it's
I'd like
presented.
to get
As
some
far as the committee
information out
goes,
of
I
it.
think that would be something that
You guys
schools
do.
should do.
Right.
And then you put up some sort of plan or several options that we can look at. And
The bottom line is
that
the
would be
workshop's
easiest.
intended to let them hear all the ideas, ask a lot of questions about what the heck do you mean by that, and then the public hearing is to really bang out which one of these options we think are acceptable to us. And then they harden it. Then they direct me to put it in final form. Then I check with the attorneys to say, is this acceptable legally, or do you want to rewrite it for me so it sounds okay? Then to the adoption hearing, it's basically, this is a blessing hearing. It comes forth, they announce it, they read the provision, or whatever, however the process works, and they bless it. If they don't want it, they send it back to public hearing again. See what I mean? It's a final thing where the board says, we're putting our reputation on it now, and this reputation will be going before the Legislative Commission. And it'll be argued by us. We have to defend whatever the heck they do, so it'll be me and probably the board chair and whoever else, the board members that are going to testify on behalf of it. That's how it works. Normally, we get into very mundane things. There's no argument. Nobody cares. They bless it and move on. But this one will be a little more of their territory, because they don't want the problem of having more taxes, schools closed. That was a big issue, and they said, "You mean you've got one school out of compliance?" I said, "Yeah, it's been 3 or 4 months now, and they've worked with me, they've kept me abreast of the issue, but they can't get a bond." And I said, "This is how it's going to work. If you don't pass this law or some modified law that'll deal with this issue, I will close their doors come July 1st. And that's an administrative position. And they said, "Fine, we understand. We understand you're trying to do the best you can with what limited flexibility you have." That was the only options I have. Now, with the law being repealed, it means the door is wide open again for new negotiations of how we put that back together. So that's a grace period for everybody for a few months. Now, I've got to high speed it because they said July 1st. They didn't say October 1st. They didn't say December 1st. They didn't say January 2012. So I'm stuck. I got to move it as fast as I can. So the issue for you is from this meeting, figure a month, and we're going to be starting a public workshop. That doesn't mean you missed the opening. It just means that it would be nice to have gone through the, hitting the ball back and forth a few times to see
So we
if
can
it...
give suggestions.
Yeah, and then I can say, I want to be honest with you. You may not like me for it, but I'm going to tell you what I think will work and what won't work, or what I heard the legislature say. They were very crystal clear to me, because I got to deal with every single legislature that heard this bill. I met with every single one-on-one. And they'd say, "I'm not going to say this publicly, but this is what I want." And I got that a lot.
My understanding on this payment plan is basically the student would not pay in advance for their training.
No, the opposite. The student, I haven't figured out all the payment periods under the new provisions of the Title 34 stuff. But the way I saw it was that the student would pay up front a portion of the education.
Right.
And that you couldn't collect it all at one time.
Right.
But you'd have, say, 3 payments or 2 payments
Yeah,
or
we
whatever,
have 4.
sort of like the feds do it. But, my vision was originally, the way Ms. Carlton wanted was, they paid for 25% up front. And then somewhere between 50 and 75% was a mark you could bill again for the next period. But you had to get at least that mark before you could send the invoice for it.
So you would have to make sure your students are in compliance.
Yeah.
Right. Well,
And the reason,
with the new, there's no more year-round Pell. It's all by the 4
Yeah.
payment
Right.
periods again, and it's at the end. The staffs have to be done at the end of the payment period now. There's no more 25.
yeah,
and all that. There's
see,
major
you
changes.
guys are hooked because the feds have the money.
Yeah.
You don't get it until they've completed.
Well, it's going to be the same when the student pays the schools, right?
Yeah.
No, the original plan was that you pay 25% up front, on the front end, and then when you got about 75%, you bill for the second portion of it, and so you're always on the positive side of the equation. What that does
No,
legitimately...
she wouldn't be on the positive
No.
side.
Why not? I don't understand the
It's
economics of
under
that.
tuition.
I don't understand the economics of explain to me.
If they're paying 25%
Up
of their
front.
upfront,
Before they get
And
it
if they
done.
Okay,
drop
now-
out, then you've got a refund policy to deal with. Well, at least with accredited schools.
Right.
Okay, that's number one.
Well, don't get that.
No, wait.
Wait. You just applied a standard that we didn't even talk about. Has nothing to do with the standards that we'll accept. So we have a refund policy. Maybe that has to be changed. But we control that, not the feds.
No, but our accrediting agency has a
You-
model,
you-
and the
you
feds
can't
have what's
use your
called
state.
return.
Okay,
Yeah,
that's
but
if you're using
the
federal
accreditation.
funds.
Wait a minute, Kathy.
Wait a minute.
The accreditation agencies will respond to state law.
No, that's not correct.
Well, I talked to the Fed people and they said, yeah, we do make
the
modifications.
accreditation gives you a guideline. The federal government has what's called return to Title IV.
For federal money reimbursement.
60% of a payment period. If a student doesn't exceed.
That's correct.
It doesn't go beyond 60% of a payment period. Most of the Title IV has to go back. Now, my issue, what I'm looking at right now with this payment plan, which I think is great, however, are we going to, if we have cash paying students, one set of law is going to be applied to them, one section like the 25% and whatever, because they're not under a payment period.
You can't do
Will have to be
that.
treated for all, because I know the staff policy now has to
If
be for all
whatever that
students.
policy is.
So whatever it is, it would have to be modeled. There wouldn't be a
You
separation.
can't do it for one set of students
Right,
versus the other.
right, I agree.
Well, then, if we modeled it, then you wouldn't get any money from anybody until the first 50% is done.
No,
Because that's how they
Then
pay.
you get to pay out the student in the federal money, and then at 450 hours, we have 2 academic years in Nevada, according to the feds. when they first start, you can pay out the first part of the grant, okay? First half of 5550. When they hit 450 hours and meet satisfactory progress, you can pay the other half. Of the
God
grant.
bless you, just describe what I put on the table the first time.
I'm
And it was
just telling you how
rejected.
works.
It was
No,
rejected by people, schools in this room, didn't like that idea.
Well, that's the way.
Now it's coming back to that again.
Well, that's because the federal government changed for a while and let us have year-round Pell, and it got to be a lot different. Now they're back to the old
That's not true,
routine.
Vince.
Well, it was recommended originally, Gwen, 25% up front, 75% completion of that quarter, and 25% again. What's different than what you just described?
Because it's 2 academic years, which is 2 pills.
But that's because you got all these confusion things.
75%.
Well,
That student.
what I don't want to hear is that the feds are going to tell us what to do, okay? Because we're saying we'll model after them, but we'll modify it so that's acceptable to them and is acceptable to us too.
Well, then you're going to have to basically model it right after them because
I
if
doubt
you're
it.
dealing with cash paying students and you're dealing with federal aid students, you have to do whatever the federal government says.
Now here, wait. What occurs now with the feds is you never get all your money all at once, do you?
No.
No. It's a payment plan.
Right, but if you set a standard of 25 and then 75%,
75% of the first quarter.
No, 25% billed, 75 completed hours of that first quarter, then you bill second set.
It's not 75%.
It's not 75% of everything.
Okay.
You're never going to be behind. Economically, by economics, it doesn't compute when you say it don't work.
well, it
Because
seems
simple economics tells
No,
you
the
that.
way you were saying it was rather confusing.
That's what I was trying to, that's when I cut in because I knew that's where they were going.
When I said, because Miss Carlton put it on the table originally, the plan was 25% billed on the first day. When you sign the contract, you bill them for 25%. You can't bill invoice for the second 25% until a certain portion of that education has been received and validated for the student. Then you can invoice the next set. And everybody tells me it don't work. It don't work. Well, tell me how, because economically it does.
Quarter in there.
Yeah, in other words, it would be if they completed 300 hours out of the 450, that's say,
That's the
I'm just throwing that
threshold.
out there. It's, okay, 75 or 60%. Okay, I knew that's where they were going, and that's what I was trying to
Yeah, that's
stop.
yeah.
Well, no.
Right.
You,
When you say 75%, you're
of the,
you're automatically thinking 75% of 18.
no one really heard what was said because it was really laid out, and the legislature understood it completely. They said that looks logical to us. You're not billing for anything that has, you're only billing 25% out front. So what's the real issue for them to understand that? The liability of the student is this small instead of this big.
Right.
That's the issue. That's what they want to see happen. That's their goal.
And with refund calculations and that, you know, if a student walks in and gives you $15,000, that's what your tuition is, and they drop out, you still have a big refund to pay. So really, without having the surety bond, I don't like the idea. I've
Well,
been
tell
dealing
me
with
what the
our
surety
renewal.
bond would do for you if you let the surety bond lapse as you go
Oh.
bankrupt.
Exactly.
Nothing. You have nothing. Because there's no way to get the money.
Exactly.
So the issue is the board is very clear that what we were doing was saying, why are we in a cosmetic solution that don't work? Why are we doing that?
Right.
That's what the dialogue was all about. Finally, after going through 100,000, 200,000, do we do this, do we do that, they finally came to grips with the issue. What the hell are we doing? Why are we in this business of requiring a surety bond that don't work? So we went to
Now it's
the...
going to give the schools the option if you got a cash paying student and you got more cash. A lot of schools have been taking a lot of cash students too.
I'm not worried
So
about the
they give them
federally
option.
funded.
They want to take their cash up front.
Well, that's not what the feds are going to, I mean, that's not what the state's going to allow. The state is saying we're not going to do that anymore. There's too much liability with no guarantees. If you guys can put there's a fund that you pay for that guarantees that you're solvent and you can deliver. And if you fail, that money goes directly, that's one thing. But I wouldn't support the students paying for it.
Well, but you know, at one time with the STRAF in California, the schools actually paid. And then the legislator, there was some rebuttal and everything with school owners and everything, and it went back and forth. Finally, they came back and said, okay, the students pay.
Yeah, I don't think the
Okay.
state will buy it.
Well, right now, it's the students' pay, and they bill us quarterly, and we actually pay it, but we collect it first.
Yeah, you charge them back, so it's a tax override.
I want
It's
to
a surcharge.
Pay them up.
I want to add, because you seem to me like you're having something over there that you want to say, and I want you to say it.
And I'm never quiet. I'm just, to me, when Gwen said the surety bond should be a choice, sure, it should be a choice. But what I've taken from this entire meeting, just sitting here listening, is that you guys are saying the surety bond is cosmetic and not needed. It's not really something that's going to benefit the student. You know, we come from a larger corporation than Euphoria, so we see things a lot differently than a lot of the smaller schools see. So I'm only speaking from a company that has 40-some schools. But to me, I just feel like if you're saying it's something that we don't need, why are we arguing about it? But, you know, at this point, if a business decision, I pay $4,000 a year because I'm the newer Euphoria. I think Lou probably pays a lot less than that.
Yeah.
But we have a good reputation. So I'm sitting here thinking, then why would we have the surety bond? I closed a campus. I closed a campus for Lincoln Educational Services. There were teach-out programs, there were transfers over.
Right,
So
exactly.
the student didn't get screwed over. Call it what it is. That's what it is. You don't want the student to pay up front. You close the doors, and then you give them nothing back. But what I'm hearing is the surety bond, what is it going to give them back? So why do I have it? What is the surety bond for? Can someone tell me that? I'm going to play really stupid because I don't know.
I agree with you.
What's the surety bond for?
That's why this was brought.
It was
Why
the,
are we arguing?
One of the
Because-
he said something very important. We are required, being an accredited institution, and those of you in the room will agree, we have to have a teach-out plan. Why not look at that formula with the other schools?
because again, let me explain politics. You don't have a choice because the Fed said you will or you don't get our money. That's the game that's played on the table. You want to get our money for your students, somebody else picks the tab up for it, you will have this, this, and this. When you stop complying with that, no more money. That's how it works. A private industry, a school that does not have federal funding, has none of that.
But what I'm saying is, why
And
does
you
the
can't
state board
teach-
create a teach-out plan
That
and
doesn't
have
work.
all
There's
the
no
schools
requirement.
rather than a
So I
bond
go bankrupt. How are you
participate?
going to enforce it? Well, what do I do? Go out and beat them? Catch them with put thumb screws on them to get them to pay the money? Or they don't have to. They're
Look at how many
bankrupt.
closures there really are. There's minimal.
There's 3 in this state out of 17 the first 2 years I was here.
Yeah, but that was, what, 6 years ago?
No, that was less than 3. Bottom line is, Christy,
I guess I-
to answer your question,
Plan-
that's what the board came to the conclusion, that it was a cosmetic or anti-business issue. In reality, there was never money for the students when the school actually collapsed.
But I think, Christy, the surety bond was for just making sure, because I was around when they increased the amount. I was a part of that. Originally, they wanted it to be $750,000, somewhere in there, and the legislation came back and said, that's too much, $400,000 sounds to be fair. But what I believe the surety bond at that time, and I don't know now because of the economy, but it made sure that the schools were financially sound, because you do jump through hoops to get that bond. You have to show that you have X amount of cash in the bank. You have to show that it's much better to me to have something in place than to have undercapitalized schools. It's the bottom line.
I get that. I'm just saying the $400,000 surety bond that we have cost us out of pocket $4,000.
Right. It cost me 12, so I understand.
Right.
It's expensive.
We had the reputation. They've been here forever, so I was piggybacking off of someone. The question for me is, I mean, if you have 100 students and you close the doors, these people are out. I mean, don't misconceive that we had a teach-out plan. That was a courtesy of what Lincoln's integrity was, which was we're going to find a home for them. The ones that can't be part of the teach-out, we're going to pay them back because they had the financial ability to do it. What I was trying to say is that the surety bond wasn't the savior.
Wasn't the factor.
Right.
Wasn't the savior. And it was a courtesy. So I get it. In business, when you're a smaller school and you're not corporate, you know what I'm saying? I get that. And they have deeper pockets. They can give more. But to me, honestly, as I'm sitting here listening to everybody talk, I see no value now in the surety bond for our campus.
Right.
But it's not about us, it's about us as a whole. It's about what's going to benefit everybody.
So what you're going to have to think about is, first of all, what's that surety bond? I still believe it's cosmetic. Most of the schools we're finding, and that's what the insurance company says, they let them lapse before they actually go bankrupt or slam the doors closed. And the schools that have federal funding are not a significant problem because the teach-out requirement, and that's how they get around federal funding issues, is the teach-out requirement is built in. And so other federally funded schools will accept the students, usually on some kind of negotiated basis of how many hours will be accepted. We validate all the hours. For a school that's not federally funded, don't work. Nothing work, period. The students are on their own. So the surety bond is cosmetic in nature. Now the issue is you can't confuse regulations because you run an international airport versus a county airport as the same type of airports. And that's what happens all the time. So those who are in federal funding look at the federal funding rules and say, well, that's getting in my way. Now, the trouble is we have a sovereignty issue here. The state has a right to license, period. It should have the right to dictate some of the conditions in which you function. If you want to choose as a business the right to go get money from a third party, federal government, that's a business decision that you make based with all the factors around you. That is not dictated to you. You choose to do that voluntarily. And when you do, there comes with all these regulations you have to comply with. Now, the state has no intention of violating the federal payment plans, but we also are not going to let the feds tell us how to do our business in our state. Be sure of that. The local sovereignty has jurisdiction for licensing, and so we craft what you need to be a license established in this state. Or you can move to another state that's more receptive to you. But if you want to work in this state, then the regulations are going to be compatible with the feds, hopefully, when we come to final solution of how the two operations work. But they will not be dictated by the feds. It'll be modeled after, and it'll have payment plans that are similar in nature, and hopefully not too complex to run.
Well, who's going to monitor that?
Well, we're going to have to, because your license will be at stake for it.
How many non-financially participating schools do you have in cosmetology in the state?
Say that again?
How many non-Title IV schools do you have?
Well, I don't know what there is now. Too bad Annie's not here. There's probably, well, there's a number of them trying to get it. They're in the final stages of applying and what have you. There's about 5 or 6, maybe 7.
Okay, and how many total cosmetology schools in the state?
We have 19.
19 plus 5?
No, minus 5.
Minus 5.
There's 11, I think. Gwen, do you remember the list I sent you? There was one out of place, but I think it was 11 on one side and 7 on the other side. Yeah, and that had to do with what that list had to do with 10,000 versus 400,000. Now there's a number of schools. I can see if I can remember them. Advance is not federally funded at this time, but attempting to. Paul Mitchell up north is trying to get federal funding because they're not eligible yet, but they're in the process of application. Paul Mitchell South is in application now. James Albert is non-official federal funding school. I think there's one other. And what it is, you have to be actually in service for 2 years minimum before you can even apply.
For what?
To be federally funded. You can't operate first day because you got a lot of money.
No.
And say, I want federal funds.
Right, yeah.
Now, why do you do federal funds? Because it is a guaranteed stream of income.
Right.
It's a business decision. Understand what it is. It's business. That's my bag, business. But I happen to be an interpreter for government.
So you know there's more safeguards with schools that have federal funding, and there's no safeguards.
But there's no
that
federal.
students-
The only safeguard there is you could move your students that are under federal contracts to another school. Anybody you take in as a cash payment person don't get covered. You better have something to cover them. And that's what we've seen. The one federal funded school in Snook Most of their students were federally funded, but there was about 10 of them that weren't. My grandma bought the product up front with a cash check. They lost. It took them years to track them down and do all their thing because their surety bond was not there. And they let it lapse. They were going out of business. They were retiring. Why pay another $4,000 for another year?
I've also heard claiming on the surety bond is a real endeavor as well. It's not so.
That I don't know. I do know that many of the kids that we've dealt with had to go to judicial district court, file a claim, got awarded the money, and can't collect
Off the surety bond?
because the surety bond is not big enough.
Yeah.
One was $10,000. It paid 2.5 people. Well, actually 2 1/3 people.
I would love to contact some people at the Bureau and see what I can find out about the strep up there and see what insurance company they use.
When you say the Bureau, who are you talking about?
Bureau of Private Post-Secondary.
In Nevada?
No, California.
Oh, California. I called them because I want to control the quality of the hours, make sure the hours are legit. They don't give me the time of day. They don't know. They haven't done inspections. No, I know. I've talked to the big dog. They said, well, we really can't. We don't do that many inspections.
Well,
We don't really
the
know.
issue with the hours, okay, is these students figure out a way, believe it or not. We're looking at a fingerprint system right now. Because what a lot of them do with the pass cards and everything else, all this electronic, they give them to their friends. They give, they'll say, hey, John,
I understand.
clock me in today and all that. The only ones that seem to work is the top print.
I got mine.
We've got a number of schools we're running a list of California schools that we think they're selling hours. We already know. We know all that's going on.
I can give you a whole list of them that I know for sure.
The bottom line is we're here for another reason, though.
Right.
Bottom line is in the materials I gave you, it clearly outlines what the flexible areas are for input. You can influence a great deal the board's attitude about where we go from here. If you don't have any ideas, the board's going to make a decision on its own from what it sees the problem and what it needs to see, what
Are
it
you
needs
going
to
to
do.
send out something?
No, I'm not going to notify you. This is your responsibility.
No, I mean, if we send in things, but are you going to let us know ahead of time where you're leaning?
No,
You're not going to
I'm taking information. My job is to conduct the meetings. My job is to advise the board what I think will work and what it don't. Sometimes they take my ideas. Sometimes they say, go to hell, we'll take that idea.
So this is
But
the
he
way.
will make sure.
But they'll get everything
he
you
will get
send in.
everything you send.
Okay.
Everything that you guys bring in
So we can
will
compile
be
it.
given to the board as part of the workshop and the public hearings.
So if we have ideas, we can email a letter directly to you.
Yeah, you can. And they'll get a copy of what the materials are that you sent in. And if you want to know what my opinion on something is, whether it'll work or not, I'll tell you. But that's worth about less than a half a cup of coffee. But other than that, I'm cold at that.
So you said earlier that you overheard the conversation, nobody would commit to it, but what they would accept, because obviously we don't want to start going down.
Not the board. I tell you what,
No, legislation, I'm sorry.
the legislators made it clear on one-on-one conversation what they think is appropriate.
Well, so we probably need to know.
That's what you're seeing, by the way.
Okay.
That's what they told. They get it because when they finally got around to what they wanted to do, the 2 or 3 players. Now, the legislature has major players in the system. Maggie Carlton is one of them. She was an assemblywoman. She was a senator, and now she's assemblywoman. But she chaired under the Senate when she was a senator. She was on the Commerce, Labor, and Energy Committee, and she chaired all boards and commission activities for the Senate. So she's the technical expert. When she speaks, everybody listens because she's the technical expert. Now, she's on the Assembly Committee, this committee, who threw in the surety bond issue. So that she made it clear. But we've heard from the committee, each individual committee members, from each of the committees. So
What you're asking is where she was going, which is what I said.
What's going to fly?
With her, she wants to see the payment plan.
she wants what Ben said, one
That's, and fact, that's what her initial thing was.
So then what I'm hearing is, because if we go a different direction, even though we think it's a great idea, if it's not...
The board has to, our board has to accept it.
Well,
Right.
it's something that all of us, not the schools and the board, that we can all negotiate on and make sure that it's right.
But I think my question is, if we do all this research and we come up with a totally different plan than the payment plan, I'm not saying that's what we're going to do, but if we do...
I doubt if it'll
And we
fly.
present it to her, is she going to go...
No, we don't
way?
go back to her. We don't go back to
It'll
her.
go to, it'll, okay.
The board goes next,
And then it
goes to the commission. She's not on the commission.
But she doesn't have an opinion.
No more stay. She says, what I said is in the law.
Okay.
Okay, so you have the final say, the Board of
Yes.
Cosmetology.
Well,
No, but then-
technically,
Well, before it goes-
technically the legislative commission has final say.
Final.
But they're going to, 99% of the time, they say, board and commission, you were assigned to do this task. What's your recommendation?
So this, I think my question is then what I want to hear from you, and if it's in here, it's in here. But what's your opinion? What will be accepted by
The legislative
legislation
commission.
down the road?
If they follow the law as it's written, and you read it closely, they're going to say what Gwen did. We want to see a number on the surety bond that the board thinks is the right number,
For option one.
and we want to see an alternative fashioned after Title 34 of the U.S. Education's Code. Not exactly like it, but fits the needs to protect the student.
Okay.
That's what they expect to see. Anything less than that, or a variance from that, will probably draw a big question mark at the Legislative Commission and a lot of dialogue.
Do you think, now, I mean, I only know this this is experienced through a contractor's view as far as my husband's a contractor, and we have to pay so much a year into a fund for people that come into the state and don't do what they're supposed to. Now, that might be, I don't know if that's something that they'll accept along with.
Yeah, I don't. That's if say a proposal comes like that, a payment plan of some type that attaches also a fee for a retention fund, a recovery fund, whatever the heck they call it. It's not new in Nevada. There's a couple of series of boards that do stuff like that, but it's in a law already. That would have to go back to LCB to say, do we have the authority with the law as it's written right now to do that kind of addition to a payment plan or in addition to? They may allow us, they may not. I don't know. We'd have to ask the lawyers.
And that's what the contractors board, that's how the contractor board operates. Is fee into the-
Yeah, every Nevada contractor, which that helps. It also helps the homeowner if a contractor does.
If defaults on the
doesn't finish
contract.
job
That's kind of the
or
same
And
whatever.
is that tied into their licensing?
But the contractors pay the fee up front
Yeah.
as a member to the
It's a
fund.
flat fee. So, okay.
Well, they've
Is
got
it-
to be
is it
having
like-
an
is
insurance
it like
company
a-
identify it. I mean,
No, the
if we
state-
have 5
No, that's not how it
home
works.
buyers that go down because
What
of
they
a
do,
contractor.
no, the fee is handled by the state.
Oh, it is.
The state treasurer has an account that the money's deposited in, and it sits there earning interest. And then when they have a failure, then you make a claim against the fund, and then it has to have reports and all that, but then that's who pays
Well,
it.
that's kind of like what
It's not an insurance company that does it.
So we're going to talk about the hair braiding?
Okay, now, you guys done with that? Everybody understands that? Now, the hair braiding part of it in the document basically says we came forward with a bill without even thinking about hair braiding. We were already working on another plan to say, what should we do with hair braiding? Because we know it's coming across the country. We've seen a number of different states make the adjustment, and my staff and I were working on what is the solution state to state, and what should we do? And like I said, it came from outside. A third party came in the door and got the bill sponsor to put it in. And then they asked us, well, what do you think we should put in? Some of my staff want 600 hours. Some of the staff says 300 hours. Some of the staff says leave it as it is, that kind of stuff. So we were working on it. We were around, the bottom line for us was somewhere around 300 hours plus to minimum in infection control, Nevada law, clinical practice, and I forget what the other one is. So anyway, we were doing it. So I told the sponsor of the bill, this is what our staff is looking at the moment. Well, they included that in the bill as 250 hours, And they decided that was enough. They started with 8 hours. 8 hours of training on infection control, and then you'd be getting a license. That's where it started. I said, no way, we can't live with that. We'll let the bill die. And they said, well, what is it going to take to keep the bill alive? So that's how we got to the $250. I started with a little higher than that, but they rejected me. So that's how we got to $250. So that's where we are. So what is now, the staff is working on establishment, the people in the African American community that have contacted the board. We had one presentation in June or July, where Juanita Williams, and the other ladies came. Anyway, they made a presentation that was not real articulate or well comprehensively designed, but it had a good tone about we need to do something about this. The board directed the staff to go back and look at hair braiding in general. Right now, the hair braiding was that you had to be a cosmetologist or a hair designer to do hair braiding legally. Many of the people we've been talking to are what they call cottage industry people. They do it at home in the kitchen, and they do it illegally. There's no concerns about infection control of that. And some of them are very good, some are bad, but it's an industry that's under the surface. So the third party that came in said, I think that's an agreeable compromise, and that got transferred to the different subcommittees of the legislature, who said, yeah, it looks reasonable to us, whatever that means. So that's how it got into the legislation. The legislation is pretty clear what they want to see. They want a new license. We got to start issuing them July 1st or thereafter, as soon as possible thereafter. And they've set forth the requirements. They say in establishment, we have to develop regulations that deal with the establishment. What does that mean? You got to be 4 foot by 4 feet, 12 stories high. Being facetious, of course. Or what does it got to have? It's got to have a sink, to have a restroom. What kind of things you got to have in the establishment? Secondly, the practice of hair braiding. What kind of training in the 250 hours? I've designated large chunks. Schools really need to say, we can do it and we can put together a curriculum for that 250 hours, and this is the priorities to meet those goals. That is yet to be determined in detail. And also, what are the things we want to make sure that every cosmetologist does not do because it's dangerous or infection-oriented. Example is, we saw examples of, luckily the person that was involved in asking for this bill deals with cancer patients who lose their hair. And they do reconstructive kinds of things that deal with people who are extremely very vulnerable to infection problems and diseases and things like that, and are already under chemotherapy in those, but they've lost their hair, and they help them either build a wig, or weave hair that makes their hair look more natural and them as healthy people and stuff. So the issue is, what kind of regulations you guys think should be applied? You teach the stuff. What should be in the regulations? Now, the board's going to do that. It has to do it one way or the other. So they've got some ideas. We have a number of cosmetologists. There's 4 on the board. They're all qualified. They know what they're doing. We have 4 members of the staff that are all qualified cosmetologists that know what we're doing. In fact, some of them are inspectors and know what they're looking for. So those folks are making recommendations of what should be in the regulations. So that's what we need. If you have ideas like what you'd like to see in the regulations to protect your students, to help your students be safe in the industry, let us know. Because the majority of the stuff is basically health and sanitation, infection control stuff. So those are the areas you can influence too.
So do we have a hair braider's exam already?
No, but there are some out there.
There is one.
The NIC
We
has
don't
one.
have it.
We'll buy it. We'll buy, and we'll be bidding our testing systems out again this coming latter part of the year.
Please don't say that one system we had before.
Huh? Well, I remember Experior.
Oh.
Now, there's companies that are looking at us right now are NIC because they want the business back. Pearson View. There's a one up in Washington that works all the state of Washington, and there's a couple of others they have couple of hundred schools they deal with. They do schools for aviation, nursing, doctors, lawyers. So they're like Lincoln schools. They're broad-based. They have a lot of talent. They have the psychometrics people on board and all that. And some of them have several states that they already work with in these areas. So we're going to look at rebidding it. The hope is getting NIC or better. And the secondly is if NIC has one and we want to test this year, we'll buy theirs. And it'll be based on a proven product already. So but my sense is, though, what do we want to include in our stuff? We tend to copy either Pivot Point or Milady's or Click's textbooks. So when we look at a testing system, we say, how does it match to what's taught at this school, our schools? And if you guys, most of you guys are using what, Milady's or Pivot Point?
Yeah, well, those
Solid
Those
teaching.
are also coming out with just a chapter on hair.
Yeah, they're coming out now with stuff on it now. So we'll probably buy it
for sure.
when
Milady does.
we won't do it. But and any other questions on the hair braiding? So it's regulations. That'll all be discussed in the public hearings and the workshops too. They're all bundled together, just different topics. Okay? Because we're going to move this all at one time through the system. The last thing is we are in the final stages. We just finished doing our Nevada law test that the board has opted that wants to put it back in the system. We are not going to implement that until later, probably early next year, likely, because our next board meeting is October, and we promised the board to bring back and get final permission to proceed forward with the law test. Now, here's why it's not going to be until probably the first of the year sometime, and we'll warn you when we got it approved, is that we have to integrate it into the desktop computers, and we have to make sure we can validate the questions, and that DoIT can help the Department of Information Technology can make sure our system is secure and solid, that kind of stuff. So those are all the things that have to be done in the process of getting approval. Look for it sometime after the first of the year. I will give you notice, likely 30 or 45 days notice, saying even maybe 60 days notice. But realistically, you should be teaching the stuff we're asking. It's pretty
Everything
basic.
that's on those questions is in this
In that book.
And it's referenced.
Every question is referenced to a specific law.
So when a student comes down to do their application, can they pick up the law's book and does that cost them?
That should come in.
What they normally do is the schools either give it to them or they can buy them. We don't give them away.
Okay.
You can look on for free on the internet.
Okay.
You look on our website, take a look at NRSs or NACs, and it gives you the whole thing. You can print them if you're not cheap. It's only a couple hundred pages. I print them all the time because I highlight everything. Yeah, I do have cards if anybody wants my card. If you have an idea and you just want to sort of expound it publicly before it gets out to everybody and you want to talk about it, make an appointment, give me a call. Sometimes if I've got enough time, I'll even come by and we can chat about what your idea is. Right now, though, again, remember, there is no one in violation of the surety bond requirement. No one. But it's temporary. Sometime latter part of this year, it'll be established again. Any other questions?
So we can email you our input on the surety bond.
Yeah, anything you guys are proposing as either an individual or a group, let me know. They will be giving it to them, and we'll bring those. We will tell the board members that we're going to talk about those issues at the workshop. Any other questions? Hopefully I've tried to make this as simple as possible so you understand. And Christy, you did a great job of rephrasing it.
Really?
Any other questions? Okay, with that, I'm going to stop the recording. You can swear and do those things you do now.
You didn't do that during the meeting?
No, we were pretty good considering.